with murder and are found guilty of murder, at some point you could get probation for murder. And I know some people who have been convicted of murder, and you know what they say, prison is really not the place for me. It's really not going to help me. I need to be on the outside.
Yes, Your Honor. Present.
All right. This is sentencing.
Yes, that's correct, Judge.
All right. And state on this one, the court had a question, or the court wanted the criminal history and whether there was any gang affiliation.
Also, Your Honor, as a housekeeping matter, I was appointed less than 10 days, so I don't know if on the record we need to address that before we begin.
Oh, no, we did address it on the, because he wanted to go forward with sentencing. I said, please don't do this because.
I remember, yes.
Yes, but we'll put it on the record as well. Well, before we go on the record, Mr. Bell, would you like to give your attorney more time to prepare a mitigation packet for you? All right. Have you had a chance to discuss with him about mitigation?
I have, Your Honor, yes. We've discussed that at length ever since being appointed on the case.
All right. The court is calling 2024 CR 3093, State of Texas versus Dylan Christopher Bell. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense.
Renee Munoz.
Are you Mr. Bell?
Yes, ma'am.
All right. And Mr. Munoz, you were appointed to represent him. I know from our last time we were here, the court sort of insisted that he give you more time to perhaps present mitigation evidence for him.
Yes.
And at least give you 10 days. I know he was balking a little bit at that, but ultimately he decided to give you more time. Is there something you would like to place on the record?
Yes, Judge, just briefly, I did speak with my client about the 10-day notice requirement for substitute counsel on a matter that's being set, especially something like sentencing. Did stress the importance of allowing me time. We have met on that date as well as today, and I have been working on his case aside from that. So speak with my client about those preparations made. I believe he's comfortable to proceed at this time, Judge. He's been in custody for the last 177 days pending this charge. So I think that's his wanting to get the sentence done over and done with, Judge. But we're respectful of the court's consideration, allowing us the time that we need.
All right, thank you. And counsel.
This opening sounds philosophical, but it sets the tone fast when defendants talk about probation for serious crimes. Judges immediately weigh accountability versus rehabilitation, and that balance is never guaranteed.
Were you able to review the criminal history?
Yes, I was, Judge.
All right, state. All right, according to the plea that you entered into on May 9th, you entered a plea of no contest. The court found that there was sufficient evidence to find you guilty. However, the court deferred finding of guilt as you had applied for deferred adjudication and for community supervision. According to the plea, punishment is to be assessed at 6 years in the prison. The state is opposed to your application, and this will run concurrent with County Court Cause number 727864. All right. State, you're opposed?
Yes.
State, you may present.
We don't have any witnesses, Your Honor, but argument.
All right. Defense, do you have any witnesses?
No witnesses, Your Honor, only argument as well.
All right. State, I'll hear your argument.
Yes, Your Honor. Just due to the fact that this is a burglary of a habitation, this person actually was inside the home when it was burglarized. The reason that we have a reduced sentence here, the state believed that they took into consideration the fact that the individual left after he was yelled at by the homeowner, but also tried to take the car. And that's where the restitution of $248 comes from, Judge. So that's why the state is opposed.
All right, defense.
Yes, Your Honor. My client is 21 years old. He's had no previous felony convictions. In fact, he was placed on deferred adjudication on the misdemeanor case. My estimation is they're wanting him to pay restitution on it, learn from it, grow from it, Judge. And speaking with my client, I spoke to him about his upbringing because the juvenile offenses did want me to.
All right, everyone, please make sure you whisper.
The juvenile offenses did want me to delve in deeper as to his home life was like back then. He stated that he did not ever have contact with his father whatsoever. He had two brothers and a sister, and his mom was raising them all. Admittedly, she worked full time to support and raise them, so we didn't have a lot of parental supervision growing up. Essentially, he would go to school, go home, hang out with his friends, do drugs, skateboard, do things of that nature. He started off using marijuana and cocaine at the age of 15 with some peers that he was hanging around with. And that usage has progressively gotten worse and worse over time. He's admitted to me, and he's being honest and truthful with the court, doesn't want to shun that. He had been using methamphetamine quite often. At the day in question of this offense, he was high on methamphetamine. He stated that he wanted to get the car just to go somewhere and drive so he didn't have to walk. He didn't want to resell it, didn't want to do anything with that. So just the nature of that has me going to the fact that I don't know what he was going through his mind at this time, but obviously it wasn't rational thought. He was in the house. He admittedly saw through someone there, wanted to get out.
This is a critical choice. Mitigation packets can literally shape sentencing outcomes once a defendant waives more prep time by betting their future on what's already on the table.
The keys, try to take off in the car. But none of that was done. Nothing violent was done. It was not assaults. It was not him wanting to prey on another person. It was just him, I believe, being high on methamphetamine, and there's a causal link between the offense and those dependency issues, Judge. He's 21 years old, still going through some immature thoughts and facts. He's been in custody ever since this offense took place on December, Judge. So he's been in the Bexar County Jail 177 days. He's had a lot of time to think about his life. He's never been confined like that, and he has never been to prison before. I think that was a good shock to his senses that he was in custody for that long. He stated that he wants help with methamphetamine usage to get a handle on that, on those issues that we believe are causing him to appear in the criminal justice system, Judge. It was placed on deferred adjudication, county court number 8, cause number 723371. He was granted 6 months deferred on that case, Judge. Being that the DAs offered him deferred adjudication and didn't merely time serve him, I think goes to an indication that they want to work with him on a community supervision basis. I do know that the listed offense is serious, being in someone else's home, and I did stress that with my client. He stated that, you know, if he had the opportunity to get help in the future, he can see clearly, he can be a contributing member of society and not a detriment to society where they're having to pay for his stay at TDC, but instead allow him to grow and address the root causes of his issues, Judge. So this is why we're respectfully asking for the chance of community supervision. He's been in custody for the last 6 months. He's 21 years old, never been previously convicted of a felony, Judge. So I don't think it's too late to help this young gentleman to change it, hopefully change his life around.
All right. So here's my question. He's had violent offenses in the past. Is that correct?
I believe just one assault family member.
He has an assault that's not associated with this case, and then he also has an assault public servant that I believe was dismissed.
That was dismissed, Judge. That's correct. I believe the juvenile offense was when he was the misdemeanor assault was when he was a juvenile, Judge, and he was on juvenile probation for that. I just think that the lack of supervision at a young age, not having his father and having his mom just work a full-time job and then have the 3 kids that he wasn't supervised. He thought he could do whatever he wants. No, there's society, there's rules, there's laws. And, you know, he fell in with the bad crowd, starting using drugs progressively, cocaine when he was 15. He's never had the chance for drug treatments. So we're just asking for a chance at some treatment, Judge. We don't believe he's going to get the sufficient drug treatment at the Texas Department of Corrections.
Oh, they have the therapeutic community, but
I just need for the juvenile adult public servant, he was on a top of probation.
all right. Anything you wish to say? You want to raise your right hand? You solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Dylan Christopher Bell.
All right, you need to keep your voice up so the court reporter can hear.
Hey race, the legal nuance deferred adjudication sounds like mercy, but it's conditional mercy. Violate once and the judge can sentence you as if the deal never existed. Would you take that risk?
Your Honor, I've been thinking about everything that I did through the stay in jail, and I just haven't had the chance to go through treatment. And I believe that this offense that I committed was because of me being on drugs, and I wasn't in the right state of mind. And I've been thinking about it long and hard for the last 6 months. I've been incarcerated, and I just don't believe that prison is gonna be the thing that helps me.
Oh, a lot of people, I can tell you this, everybody over in the box, they don't think prison is going to help them. I don't know anybody
Yes, ma'am.
who goes to prison who who thinks it's going to help them. Even people who are charged with murder and are found guilty of murder. At some point you could get probation for murder. And I know some people who have been convicted of murder, and you know what they say, prison is really not the place for me. It's really not going to help me. I need to be on the outside.
And Judge, I think that also something he's alluding to, that if convicted and put into prison, he would be a convicted felon at his young age and trying to get a job and trying to do anything, housing, he's just going to be pretty much kept down in society. Whereas if given, say, a deferred, it's not a final conviction, he can work his way off to that, pay restitution, make things right, do community service, get back to the community. And that would be a good test of him. I've already explained to him that if he doesn't fulfill the terms of deferred, that she can send you to the full range of punishments and indiscriminately send you to TDC. But he's asking for an opportunity to make it right, make the community better, and also make himself better, to not just be a detriment where he's cycling in and out of the criminal justice system because he's had a conviction, he can't get a job. So we're asking for just at least the slightest hope to keep his record somewhat clean, and have him work his way off this deferred over the years for hopeful dismissal.
All right, any questions, State? I have a question. Why are you in red?
I'm in red because I'm in segregation.
Why are you in segregation?
In segregation, because I had gotten into the fight and they punished me. More so I had gotten assaulted, but they had punished me and put me into segregation for 15 days.
Last time, Judge, he had the bruise under his eye. Remember?
This is where the defense leans hard on addiction as context, not excuse. Courts hear this argument constantly. The real question is whether treatment feels realistic or just hopeful.
Oh, yeah, I remember that. All right, so if the deputies were to let me know why you're in segregation, would what you're telling me
Yes, ma'am.
comport to their system?
Yes, ma'am. Yeah.
If Tyler, the Odyssey system, will let us see that?
That would be nice, yes.
All right.
Good.
Deputy Laura?
Is this for, he's in red for disciplinary?
Reference to that probably, but let's just know.
I don't know if that's the case or not. All right, just have a seat. I need to think about this for a moment.
Yes, ma'am.
Yes, Your Honor. Thank you.
Who's here on Christian Smith? Christian Smith? Oh, that's the one where we're trying to figure out.
To the two people that are in charge of pretrial diversion program, Judge, I'm waiting for that response.
All right, so Christian Smith, just wait a moment with us. Do you have to go to work or something? All right, so this is what we'll do then. We'll go ahead and give you a reset, and then we'll contact your attorney if you actually need to come back on that day or not. All right. Norma, on Christian Smith, if you'll give him the June 11th reset date, and then we'll see what happens. He needs to go to work. All right, are you all ready to proceed on the motion?
Yes, Judge.
Yes, Your Honor.
All right, court is calling 2019 CR 11017W, State of Texas versus Michael Paul Shoemaker. Can I have parties announced for the record for the state?
Daniel S. Clark, with State Index.
Defense?
Sean Henderson for the defense.
And are you Mr. Shoemaker?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision and cause number 2019 CR 11017W with your attorney, and did you understand it?
Yes, ma'am.
And are you the same Michael Paul Shoemaker who was placed on deferred adjudication in 2019 CR 11017W for the offense of possession of a controlled substance, penalty group 1, less than a gram, in a drug-free zone? Is that you?
Yes, ma'am.
All right, state.
Violated condition number 7 on or about the 23rd day of May 2024 at the Port of Galveston, Texas. The defendant, Michael Paul Shoemaker, part of Bexar County, without the written permission.
That judicial response cuts deep. Every defendant believes prison won't help them, but sentencing isn't about the life, it's about consequence, and judges hear the same plea every single day.
Or the supervision officers in violation of condition number 7.
How do you plead to that? True or not true?
True. Your Honor, stated there's all the violations.
Any objections to the waivers?
No objection, Judge.
Did you understand by pleading true to violation of condition number 7, the court could find it true, find you guilty, sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 7?
Yes, ma'am.
Court will find violation of condition number 7 true. Is there a proposed agreement?
Yes, Your Honor, it's to alter and amend for MRT within 10 days and GPS for 90 days.
All right. Defense, is that the proposed agreement?
It is, Your Honor, and I do want to let the court know, my client lives in St. Hedwig here in Bexar County. He works as a heavy equipment operator in Bernie and Kendall County here.
All right, so why is he leaving Bear County without permission?
Judge, he was actually going on a cruise, and that was the reason he left Bear County.
Was that cruise approved by the court?
It was not, Judge.
So is there anything you wish to say?
No, Your Honor.
It would probably be in your best interest, but okay. Probation, what are you recommending?
Patients recommending the MRC program.
All right. And so this number one that's in the motion, I'm not going to consider it as true, but what is happening to the new number one?
Judge, my understanding is that that was out of Galveston. That's ours. I didn't see
Okay.
anything pop up.
And that is correct, Your Honor. The new case is out of Galveston County.
So what is happening with that case?
It's currently pending, Judge. I don't represent him on that, and so I don't know what ultimately is going to happen with that case, Your Honor.
I'm not going to take that in consideration and not consider it. I'm sorry, I'm not going to consider it or take it in consideration since the state waived it. But allegedly,
Or yes, what the new number one is, Judge?
yes, who is
or-
the violation of a protective order with? Did he go on a cruise with the person he's not supposed to be with? Allegedly?
Allegedly, yes, Your Honor.
So where do we, off the record, where does it come in that he violated a protective order? How did that happen? That people go on a cruise and things didn't end well?
I'm sorry, Your Honor.
Did he go on the cruise? Because you're saying allegedly he went on a cruise that he had a protective order against. He went with that person on a cruise.
He did, Your Honor. And so when he got on the cruise, since the cruise was leaving the country, Judge, I believe they go through and check everybody's passports. And it was during that process that they found there was a violation or that there was a protective order in place with the person that he was going on the cruise with.
Oh, and he didn't get to go on the cruise? They
He
stopped
did
him?
not. He did not. It was right after boarding, Judge, that that he was removed from the cruise.
Did he pay for the cruise of the person who he has a protective order against?
Yes, Judge.
He paid for it, or the person who he has a protective order against paid for it?
Both.
Both of y'all paid for it. Did they give you a refund?
No, ma'am.
Okay. This is just questions that I have. I'm always curious about things. All right. We can go back on the record. You want to raise your right hand for me, please? Do you solemnly swear and affirm the testimony you give will be the truth, and nothing but the truth, so help you God?
Yes, ma'am.
All right. You can lower your hand, state your name for the record.
Michael Paul Shoemaker.
All right. Why do you have the tape around your wrist? What's going on?
So and when you get booked in the main jail, it's every stage you go through. And
Ah,
I just didn't take it off. They took me straight over this morning. So
okay. All right. This is probation's recommendation and the state's recommendation. What I'm going to do is deny the motion. Is this his first motion to revoke?
I believe it's the second, Judge.
I'm going to deny the motion, alternate amend conditions to ISF, cognitive. And with regards to his transfer, does he need his probation transferred?
No, he's living here in Bear County, Judge, so he doesn't need probation transfer.
All right, he's going to remain in custody until transferred. And has he done anything on probation? Has he completed the parenting classes?
Yes, he has, Judge.
yes, ma'am.
All right. All right, is there anything else?
No, Judge, not at this time.
All right, upon release, you need to immediately report to probation. Do you understand?
Yes, ma'am.
And you are not allowed to leave Bear County without the court's permission. Do you understand?
Yes, ma'am.
All right, thank you.
Now we pivot. Completely new defendant. New problem. Probation violations are about trust, not just rules. One unauthorized cruise just turned into a courtroom lesson in consequences.